Good morning. So the state legislature was relatively kind to us this year, and there was no legislation passed regarding special ed that we felt we needed to share with you this morning. And I'm sure there was great sighs of relief in all the school districts because you're still trying to figure out what they passed last year and how you're going to be implementing that. I know that we are. There was some federal legislation that was passed, and Pat Anderson, who's following me, is going to be addressing that. So you'll hear from her about that. So what I wanted to share with you today were our due process statistics for the 15-16 school year. This is something that we usually don't share at the back-to-school meeting, but felt that this is probably something that you need to know. We do report to OSEP on an annual basis. We will be doing this the end of October on all of our statistics and due process. We report on the infamous Table 7, and I'm sure you all wait every year for us to release Table 7 so you can figure out what's been going on. And if you haven't, you should look for it. To give you an idea of where we are, in the 15-16 school year, we had, and this has nothing to do with that, don't look at that. That's Pat, I don't know why that's up there. We had 187 complaints filed with our office. To put that in context, we're kind of steady in complaints. So for the 14-15 school year, we had 195 complaints filed. And I have to thank Christine Spock for this. She found some interesting information from 15 years ago. And in 2001, there was 51 complaints filed. So we've almost quadrupled the number of complaints that are filed. Of those, 61 were withdrawn. Either the parent and the school district reached an agreement. Generally, that's what happened. 23 were dismissed, and that's generally because it was not an issue that was either complainable or just didn't even raise something that we would address or see as a violation to begin with. 60, I keep banging that, sorry, put that down. 60 reports were issued where violations were found against the school district, and corrective action was issued. And 23 reports were issued where there were no violations found. And if you're trying to add them up and make them work, there's 20 complaints that are still active and open. So complaints have really changed a lot, and that probably dates from shortly after 2001, where we kind of recognized that we couldn't avoid addressing complaints that weren't strictly procedural. And that greatly increased the number of complaints that we were looking at. For mediations, we seem to be going up every year. So last year we had 360 requests for mediation. This past year, 366 requests for mediation. And if we go back 15 years to 2001, there was 175 requests for mediation. So I guess we've doubled. In the last year, the 15-16 school year, there's 21 mediation requests that are still active. Either they haven't been scheduled or they're about to be scheduled. We'll go forward shortly. 42 requests were withdrawn, and generally it's because the parties reached an agreement. Of the mediations that were actually held, 207 of them resulted in an agreement, and 88 resulted in no agreement. So we're actually increasing our successful mediation percentage. Of the mediations that were held in the last year, 70% reached agreement. And that's pretty much on the day of mediation. So if you look at our Table 7, it's going to look lower. It comes in around 65%. OSEP only allows us to report mediations that reached agreement on that day. So it'll look a little bit different. But as you know, most mediations, even that don't reach agreement, do not go on to a hearing. So Obviously, there's a lot that settle within a few days of the mediation, within the next week, or disappear, never to be heard from again. Hearings, for due process hearings, this year, in the 15-16 year, there were 248 requests for due process hearings. Last year, 14-15, there was 250 requests, so we're pretty stable. And if you go back to 2001, there were 216 requests for hearing. So we're definitely higher than we were, but it's not climbing as rapidly as the complaints and mediations are. And again, we will be reporting to OSEP on Table 7 this year. The numbers will look different because on the Table 7, we only report incidences of dispute resolution that were requested and completed within the reporting year. So if a hearing is requested in June and the decision is not issued until September, it's not going to show up basically ever in terms of a hearing that went forward to a fully adjudicated decision. Of the hearings that went forward in the 15-16 school year, there's 12 that are still active. 187 were withdrawn before they even got to the first day of hearing. And usually it's because the parties settle, whether it's in mediation or otherwise. 36 were withdrawn during hearing, either at the first day of hearing or within the first couple of days. And 9 hearings went to a fully adjudicated decision, which is on the low side for us, generally speaking. In terms of the hearings that actually went to decision, I'm just going to speak very, very briefly and highlight a couple of decisions. It seems like in this last year, the basic themes were child find. Did the school district follow the child find requirements? And independent educational evaluations, which I'm sure you're all so tired of hearing about or getting requests for. So I just wanted to highlight a couple of decisions. The first one, and all these decisions are posted on our website, by the way. If you go to the special education portion, you'll see a specific line for hearing decisions, due process hearing decisions, and they're there by year. And the numbers that are highlighted are the ones that are fully adjudicated. Most of the decisions on the website are dismissal, so look for the highlighted ones. We're probably a little bit behind in terms of getting them posted, but most of them are there, and the ones that I'm going to mention now are on the website. The first one is 160433, and this was issued in June, and it's an IEE decision. This parent requested the IEE before the district's triennial had been completed. So it had been begun but not completed. The hearing officer found that the right to an IEE is conditioned upon the parents' or students' disagreement with the district evaluation, but this right does not arise until the evaluation is actually completed. You can't disagree with an evaluation that's in process. Therefore, the district not only didn't have to pay for an IEE, they weren't even really required to request a due process hearing to defend their evaluation because it had not been completed. So just something to keep in mind about that. In terms of child find, and this is an interesting decision for today since you just had a presentation around dyslexia. This is a child with a dyslexia. This is a student who had been receiving solid grades, and by the way, it's a consolidated hearing. The number is 150594/160011, issued in March, if you want to look it up on the website. The student had the support of a 504 plan, was making decent grades, making adequate process, and was also benefiting from a very liberal retake policy that the high school had and that was available to all students, special ed or general ed. The parent went out and got their own neuropsychological evaluation where the student was diagnosed with dyslexia and dyscalculia. The diagnosis was confirmed by another parentally obtained evaluation That was done by a reading consultant who was also an Orton Gillingham practitioner. Even though the student had been evaluated several times at the request of both the district and the parent, she had not been found eligible for special education. So this is one of those students that's presenting pretty well in school, is passing classes, kind of the classic high school dyslexia student. The hearing officer found that the PPT should have found the student eligible for special education as a student with specific learning disability / dyslexia. They were ordered to convene a PPT, find the student eligible, and develop an appropriate IEP that would include intensive one-to-one reading instruction during an ESY program. So kind of a classic dyslexic. Another child find situation. This was hearing number 160220, issued in July. A high school student who was having a very difficult freshman year in the district's high school was moved by her parents to a private school, and the private school recommended a wilderness program. An evaluation was performed while the student was at the wilderness program. The student was diagnosed with ADD and learning disabilities, and the evaluator's opinion was that this was closely related to the student's oppositional behavior and recommended a therapeutic boarding school. There began a number of school placements. She moved between private schools, came back to the district where she was placed in their alternative high school, and was finally found eligible for special ed as a student with an emotional disturbance. Went to a therapeutic out-of-state boarding school, another stint in a wilderness program, and returned to Connecticut, where she was diagnosed with bipolar disorder and placed by the parent in an in-state residential therapeutic school. The hearing officer found that the district had not promptly reviewed the parent's evaluation and then waited too long to return to PPT to determine eligibility. The hearing officer also said that the district's IEP inaccurately stated that the student's math skills were age appropriate on the present levels of performance pages, which they were not, and this led to a failure to include math goals in the student's IEP. The hearing officer also stated that the IEP failed to address the student's emotional issues, attention deficits, and nonverbal learning disability, and did not offer the student a residential placement in a therapeutic milieu, which the hearing officer determined was necessary for the student to benefit from her education because her emotional needs, her behavioral and learning issues were all intertwined. And reimbursement for the out-of-state therapeutic boarding school and the wilderness program was ordered. And I know how you all feel about wilderness programs. Just one final hearing decision that's worth noting, and this is 160165 that was issued in July. This hearing concerns the transition to high school of a student who was identified as OHI/ADD. The hearing officer determined that the school district had not offered an appropriate program because there were not sufficient therapeutic services to meet the student's needs, and that the program that the parent had placed the student in, a private program, was appropriate. However, reimbursement for the private program was not ordered because the parent did not consent to the district's proposed evaluation. So, a little bit unusual. Some of the hearing officers are here today, but they're incognito, so don't ask them about this. So just a little update on where we are in due process, and the numbers are already growing this year too. So we look forward to another exciting year in dispute resolution. Thank you.